Dear students, dear professors, welcome to the opening ceremony of the NOHA Joint Masters in International Humanitarian Action. I'm extremely happy to launch the 27th edition of this forward-looking and I will say resilient Masters, because we've been here already 27 years. And I will say this is a moment of joy because this is a sustainable Master. On the other hand, it's something to think about, that humanitarian needs are still rising and different countries are really in a dire situation. And this is why this Masters is still necessary. As you know, there are two main elements of humanitarian action, which are assistance and protection. And the protection of civilians is really an issue nowadays. In particular, the absence of genuine political will to realize accountability of war crimes and other serious violations of international humanitarian law has deepened a culture of impunity. And I will say this is why the conference that we are going to listen today of Professor Concepción Escobar, Immunity of State Officials from Criminal Jurisdiction, is very relevant for us and in this context. So to reflect on these issues, we have the pleasure to have Professor Escobar, and I would like to give the floor to my colleague, Professor Joana Brisqueta, to introduce her. Thank you.
Thank you very much. Sorry, thank you very much, Cristina Churruca, Professor Cristina. I would like to give a warm welcome to all the participants, specifically to the new students. Welcome to the University of Deusto. We are celebrating this conference in the framework of what it's called the European Society of International Law Conference on International Law Issues, coordinated among others by Professor Ana Salinas from the University of Deusto in Malaga. And now I will be very brief, introducing to you to Professor Concepción Escobar. It's a great honor and genuine pleasure to have her here. She, in fact, has been a professor of the NOA for many years. And it's, as I was saying, a great pleasure to have her here again. She is a senior professor of international law at the National University of Spain. She's a member of the Spanish Commission on International Humanitarian Law. She is a second vice president of the International Law Commission. She is a former director of the International Legal Advisory Office of the Ministry of Foreign Affairs in Spain, Foreign Affairs and Cooperation from 2004 until 2012. And currently she is the special rapporteur of the International Law Commission on the topic immunity of state officials for foreign criminal jurisdiction. Thank you so much, Concha, for being here. Welcome.
Thank you very much. Thank you to Professor Churruca and Professor Brisqueta. It is my honor and a great privilege to be here once again. For a long time, I was absent of this master for my fault, not for the fault of the organizers, and it's my pleasure to be here again. And in particular, I would like to say that I'm very grateful I'm very happy to be able to deliver this speech. It will be a introductory remarks about the topic, because on the issue of immunity of state official from criminal jurisdiction, on behalf of the European Society of International Law, who asked me to deliver a conference on this framework. If you don't know the European Society of International Law, you can go through internet to the web page and the website, and you can find a lot of conferences having been recorded by different professors in Europe regarding to different topics on international law, international relations, and most of them are related to the issue of not the humanitarian action, but related to the topic of human rights, refugee law, etc. And I recommend you going to the page to the European Society to get more information. Of course, my conference you will here now, and it's not necessary to go to hear once again. Well, the topic I will speak today is about the immunity of state officials from criminal jurisdiction. Sorry, I will connect my watch because otherwise I can't speak a lot. The topic I will speak today is about immunity of a state official from criminal jurisdiction. As Professor Chubuka said before, it is a topic having a great link with the issue of humanitarian action, humanitarian protection, and is directly linked with two elements that I would like to underline from the outset. First of all, the protection of values of international community and of international law, the value in particular human rights, protection of humanity, and on the other hand, the principle of accountability and the fight against human impunity. And on the other hand, has a strong relation with another element, which is another principle, which is essential for international law, which is the principle of equal sovereignty of states. The interest for the issue of immunity of state officials from criminal jurisdiction has increased since the 90s of the last century, in particular, but not exclusively, with regard to the immunity of the head of states. Two circumstances could be identified as the main reasons for that. First of all, the progressive redefinition of the concept of sovereign immunities on the one hand, and the establishment of international criminal tribunals on the other. And strongly linked with these two circumstances, I have to recall the consolidation of the fight against impunity from international crimes as one of the axiological purpose of the international society and international law at the dawn of the 21st century. This interest for all institution immunity, now in connection with a new subject, state officials, has produced an important volume of legal and political writings and has generated new process of codification of international law, both at private level through the Institut du Droit International and at public level, or if you want, institutional level through the International Law Commission of the United Nations. In addition to that, I would like to recall the fact that different international courts has paid a great attention to the issue of the immunities. I will make reference later. As you can imagine, it's not possible to the time allocated for this conference to address deeply all the components of the phenomena of immunity of state officials. So I will concentrate, I will focus my intervention in the following issues. First of all, the relation between sovereignty and immunity and what is the consequence of that on this type of immunity. Second, the plurality of international legal regimes applicable to the immunity of a state official from criminal jurisdiction. Third, the work of the International Law Commission on this kind of immunity. And finally, I would like to say something in relation with the relationship in connection, in the context of the relationship between international immunity before international criminal courts and national criminal courts. Let me start with the reference to the sovereignty and immunity. For a correct understanding of the institution of immunity, I don't know, all of you are lawyers. I think that you came from different backgrounds. For a correct understanding of the institution of immunity, it must be underlined the strong link existing between immunity and sovereignty. Actually, immunity is recognized, exists as a tool for protection sovereignty. And for so doing, through immunity, or by the way of immunity, we bar the exercise of the jurisdiction of national courts, the national courts of the so-called foreign states, the territorial state, when the subject to be submitted to domestic tribunals, was qualified as a foreign sovereign. So immunity is the result to apply the principle par imparem, not habet imperium, of, if you prefer, taking into account that states are both equal, it is impossible that one state, through its national tribunals, could rule about, decide about the activity of another state. In fact, immunity appears in international law as the personal immunity of the sovereign prince, le prince souverain, an individual, who is the owner of the sovereignty. Only when the sovereignty is attributed to the state itself as abstract entity, immunity becomes state immunity. From this new perspective, state immunity is considered as the essential and preeminent category of immunity, and the immunity of the former sovereign prince remains as a residual category of vague contours. As a consequence, such immunity, the immunity of the king, the president of the republic, or other sovereign, is perceived as anecdotal and irrelevant since the end of the 19th century. Of course, with the exception of the immunity of jurisdiction recognized to certain categories of state officials responsible for representing the state at international level, in particular diplomats and consuls. However, a great evolution has taken place during the last century regarding the law of immunities. One of the most remarkable new trends has been the progressive recognition of a kind of immunity, a sovereign immunity also, with regard to head of states and other state officials. This trend has been developed alongside with a limited process of codification of the law of immunities and a new interest from international courts with regard to the institution of immunity in international law. Although the preeminence of state immunities in international law, the issue of immunity of state officials, the immunity of individuals, has continued to be present at the international level through the 20th century and to this day. Let me give you some examples. In the context of the two world wars, attempts were made to prosecute Kaiser Wilhelm, and the Nuremberg and Tokyo courts were created. Second, immunity has been continuously alleged to prevent national courts from exercising their jurisdiction over head of states, head of governments, or foreign ministers, and even other high-level state officials. For example, think about on the Gaddafi case, in Hanoverian case in France, the Gerodia and Sharon case in Belgium, or cases more close to Spain as the Pinochet, Castro, and Kagame case in our country. On the other hand, some national courts have decided not exercise their jurisdiction in respect of acts committed by senior state officials, including when the offense committed was the torture, on the ground that they were protected by state immunity. So, for example, it was the case Al-Dassani and Jones in the United Kingdom. Others, on the contrary, have not recognized such immunity, for example, in the Pinochet case in the United Kingdom, or the recent judgment of the German Supreme Court with regard to some crimes against humanity committed in Syria. Some national laws has made reference to immunity of officials or the foreign state, either in laws of immunities or in the laws implementing the Rome Statute, because the issue of immunity has gained a great importance since the adoption of the Rome Statute and the constitution of the International Criminal Court. And among theirs, for example, the Spanish Act on Immunities adopted in 2015, it constitutes a good example of the inclusion of the issue of immunity with regard to the state official, and in addition to that, the recognition of some exceptions that allow the the Spanish tribunals to proceed the acts of several state officials when they are accused to have committed an international crime. And finally, I would like to draw your attention on the fact that the International Court of Justice ruled on several occasions on immunity on a state official, and so has the European Court of Human Rights, and more recently, the International Criminal Court. In short, the immunity from jurisdiction of state officials continue to form part of the law of immunity. The treatment of the immunity of state officials in international law has experienced a very significant evolution, which could be named as a round trip. We start with the immunity of the prince sovereign, the prince sovereign. We go after that to the immunity of a state, and we come back again to the immunity of a state official, but from an absolutely different perspective. This modern expression of the immunity of state officials is undoubtedly an issue of great importance for states and the international community, which has also taken on a special significance since the 80s and 90s, when the particular problem of immunity for criminal jurisdiction and its possible impact on impunity for international crimes began to arise. Actually, at the end of the last century, the issue of immunity of the head of a state and other state officials has gained a new relevance in connection with two new elements. First, the growth of the number of criminal proceedings instituted by national courts against foreign state officials, a practice that was impossible to consider at the end of the 19th century and even until mid of the 20th century. And second, the establishment of international criminal tribunals, in particular the International Criminal Court, which jurisdiction apply over any individual, including state officials, accused of having committed crimes under international law, before which immunity does not apply. Under this new perspective, the immunity enter in contact with the protection of values and principles of international law, the fight against impunity, and the principle of accountability. And those elements become new elements to be taken into account in order to identify the scope and limits of the immunity of a state official from criminal jurisdiction. This kind of immunity continues to be a necessary tool to protect the state sovereignty, but the rules governing it must reflect a necessary balance between this purpose, the protection of sovereignty, and other values and principles of international law. Looking for such a balance constitute one of the main challenges for the international law, and it is a work in progress. In this context, the issue of crimes under international law becomes a crucial one. The relevance of the immunity of state officials in international relations has had as a consequence the adoption of new rules of international law, most of them conventional rules. At the first stage, the issue of immunities of a state official was not considered in itself, but as a component of the general regimes applicable in the field of diplomatic relations, as related in the Vienna Convention on Diplomatic Relations, the Convention on Special Missions, the Vienna Convention on the Representation of States in their relations with international organizations of an universal character, and the Vienna Convention on Consular Relations. In the framework of these conventions, a new category, it arises a new distinction between two different kinds of immunities, the personal immunity and the functional immunity of, if you prefer, I will make some reference to that later, the immunity ratione personae, personal immunity, and immunity ratione materia, functional immunity. The most, probably the best example of the regulation of immunity in the context of the international relation, the international representation of states, it could be found in the regime applicable to the diplomatic agents in accordance to the Vienna Convention on Diplomatic Relations. In this context, the diplomatic agent enjoy full immunity from criminal jurisdiction without any exception, is not obliged to give evidence as a witness. No measures of execution may be taken in respect of him. And finally, his person shall be inviolable and he shall not be liable to any form of arrest or detention. In addition, immunity of diplomatic agents covers both the acts performed in an official capacity and the private acts, which is one of the elements more controversial with regard to the immunity of state officials. The second field when immunities appear are the immunities of a state official, of course, are the immunity of armed forces stationed abroad. This type of immunity has been approached both from the perspective of the state immunity and from the perspective of the members of the armed force and the civil staff accompanying the troops. Regarding the immunity of members of armed force, it has been addressed always by conventional rules contained in bilateral treaties or more recently in the agreements on the statute of force. But at the same time that this convention and agreements have included some rules related to immunity of state officials, it has arisen a customary rule on the immunity of state officials and other other high-ranking state officials. The existence of that customary rule has been recognized in some of the conventions mentioned above and by the International Court of Justice in the Arrest Warrant case, the European Court of Human Rights in the Al-Dazani and Jones cases, and more recently, by the International Criminal Court in the case of the Jordanian referral case. The customary rule has set up an autonomous legal regime on immunities applicable before domestic criminal jurisdiction, which relevance cannot be denied, even if its scope continues to be uncertain and sometimes controversial, and show the domestic and international case law. However, it does not exist a general legal regime applicable to any state official when the issue of immunity arises before any national tribunal or court. The need for establishing such a general regime is in the origin of the works of the International Law Commission on the topic of immunity of the state official from foreign criminal jurisdiction, to which I have the honor to have been appointed as a special rapporteur in 2012. The ILC included this topic in its long-term program in 2006 and appointed a special rapporteur in 2007. Until now, the Commission has received 3 reports from the first special rapporteur, the Ambassador Kolotkin, and 8 more reports from my side. On the basis of my 8 reports, the ILC has been able to approve until now 13 draft articles, and there are 6 more articles on the table of the drafting committee of the International Law Commission to be considered in the next year. The purpose of the Commission with regard to this project is to adopt a draft articles containing the general legal regime of immunity of state officials from foreign criminal jurisdiction, letting aside the existing special regimes and the regime applicable to immunity before international criminal tribunals, which will not be influenced by the ILC draft article. If you prefer, the Commission intends to prepare a general regime not applicable when we find some lex specialis, some specific regime applicable to certain categories or state official or by a certain kind of tribunals, the international criminal tribunals. In order of a better understanding of the work of the Commission on this topic, let me mention at the outset the key elements constituting the basis for the proposed new regime, even if probably I will make some reference to this issue after. The first key element is the distinction, the clear distinction from a normative perspective between immunity ratione materie and immunity ratione personae, or you prefer immunity, functional immunity and personal immunity. And as a consequence of that, the establishment of 2 different legal regimes applicable to each kind of immunities. The second element, or the second element, is the identification, the purpose to establish or to define a new legal regime, making a balance between different values of the international community. That means, in particular, by the way of establishing exception or making a list of exceptions to immunities. And the third characteristic of the work of the Commission is the inclusion of some kind of procedural dimension, which are until now are not to be considered by any instrument, neither at international level nor at national level. Let me start by the distinction of immunity ratione personae and immunity ratione materie, because I think that this is very interesting for you to understand well what are the scope, or which is the scope of international, of immunity of state officials. The distinction between immunity ratione personae, personal immunity, and immunity ratione materie, functional immunity, is well known in the doctrine, and we can make some reference to that even in the case law or at the national level. But the Commission decided that this kind or this distinction has to be considered from a normative perspective, taking into account that each type has different normative elements, at least in some aspect could be governed by different rules. This distinction, or this approach from a normative perspective, allow the Commission, or facilitate that the Commission could establish 2 different regimes, including in particular to the exceptions to the crimes, the exception for crimes on international law applicable both to immunity of ratione personae and immunity ratione materie. To be short, I would like to call your attention. I would like to mention the three main elements that define the concept of immunity ratione materia and immunity ratione personae. The first element is who are the state officials protected by or covered by immunity. The officials covered by immunity are any state official. I will come back on this issue, on this concept later, but with regard to immunity of a state, immunity ratione personae, I have to call your attention on the fact that immunity ratione personae only applies to the so-called troika. That is, the head of the state, the head of government, and the Minister of Foreign Affairs. The other state officials, including other ministers, members of the parliament, any kind of state officials, are covered only by immunity ratione materia. And that has some consequence on the perspective of the scope from a material perspective. Second, the second element is what. What means what kind of acts attributable to the state officials could be covered by immunity of a state, for immunity. In the case of immunity ratione personae, all acts coming from the state official, from the head of the state, head of government, Minister for Foreign Affairs, are covered by immunity. Both act, private act, if you want, and act performed in an official capacity. Both, if we think about, for example, in a criminal perspective, both a crime against humanity that could be performed in an official capacity because they act as the authors or intellectual authors of the activity or supporting the crime against humanity, could be covered by immunity, but an ordinary murder, an act of corruption, a private act, will be also covered by immunity ratione personae. If we move to immunity ratione materia, the situation changed. Only acts performed in an official capacity will be covered by immunity of state officials. That means that all private acts will put aside of the institution of immunity. And the third element is when or during what time. In that case, immunity ratione personae applies, or immunity ratione personae covers the head of the state, head of government, and Minister of Foreign Affairs only during the time of the term of office. When the term of office ends, the immunity disappears. On the opposite side, on the contrary, immunity of state of immunity ratione materia is permanent. It's permanent for a very easy, for a reason is easy to understand. The basis for the immunity ratione materia is the link between the state official, the state, and the act performed in an official capacity. So if the act was performed in an official capacity at a certain moment, this act will not lose this qualification, and the immunity will keep in force for at any time. If you have paid attention, and I realize that you are paying attention to my previous explanation, you could see that there are at least two main concepts that are essential for the definition of the new regime of immunity of state officials by the International Law Commission. The two concepts are the concept of a state official and the concept of act performed in an official capacity. With regard to act performed, the private act, they are not interested because they are a civil act. And when head of state realize any act is covered by immunity, whether act performed in an official capacity or whether a private act. I would like to start by the concept of a state official. The definition of a state official adopted by the International Law Commission reads up as follows. A state official means any individual who represents the state or who exercises state functions. By this definition, the ILC desired to offer a comprehensive concept of a state official covering both the individuals enjoying immunity ratione personae or immunity ratione materia, because at the end of the day, the head of state, the head of government, and the Minister for Foreign Affairs is an state official. On the other hand, the phrase who represents the state or who exercise state functions express the need for a link between the state and its official as a sine qua non requirement to enjoy immunity. In this regard, attention must be drawn to the fact that a state official may fulfill both requirements to represent the state or to exercise state functions, or only one of them. There is no doubt that the head of a state, the head of government, and the Minister of Foreign Affairs are state officials in the context of immunity from criminal jurisdiction. Regarding other state officials, the determination of the condition of a state official applicable with respect to immunity is not so clear. It's not so clear. The Commission has decided not to identify every post, every function attributed to a person, any office in the list of members of on the condition of a state official for a reason very simple. It is different, the name, it is different, they are different, the concept, the function, etc., attributed to individuals at any national law. As a consequence, it was not useful to identify a list of posts to which we could say that they are state officials. But anyway, if you pay attention to the work of the Commission, at least the Commission has decided to offer some examples of this kind of persons. We have to identify case by case if it is or not a state official, but the Commission considered that it is always a state official for the purpose of the immunity, a former head of a state, a Minister of Defense, and a former Minister of Defense, a Vice President and Minister of Forestry, a Minister of Interior, an Attorney General and a General Prosecutor, a head of National Security, a former Intelligence Services Chief, a Director of a Maritime Authority, an Attorney General, and various lower rankings officials of a federal state, military officials of various ranks, and various members of the government security forces and institutions, including the director of Scotland Yard, border works, the deputy director of a prison, and the head of a state archives. The list I just read is taken from the practice. It's not an invention. It's are the national tribunals, the organs identifying the list of persons enjoying immunity. The second normative element is the concept of act performing an official capacity. Sorry. The second concept is the act performed in an official capacity. The Commission has adopted the following definition. An act performed in an official capacity means any act performed by a state official in the exercise of state authority. The key element is the identification of a link between the state and the act. So only if the act could be attributed to a state, even if the is committed by an individual, the state official, could be covered by immunity of state official ratione materia. As in the case of state officials, the Commission has decided not to make a list of, to produce a list of acts considered as state act performs in an official capacity, but I would like to make reference to several examples that we could get from the practice. For example, military activities or activities related to armed forces, act related to the exercise of police power, police power, diplomatic activities, and those related to foreign affairs, legislative acts, acts related to the administration of justice, act related to public loans, and political acts of various kinds. But I would like to add some other which are more controversial to be qualified as performing an official capacity. Torture, extermination, genocide, extrajudicial executions, enforced disappearance, forced pregnancy, deportation, denial of prisoner of war statute, enslavement, and forced labor, and act of terrorism. Ill-treatment, abuse, illegal detention by armed force, offense against the administration of justice, and other acts related to policing and law enforcement. If you think about the list, you could identify that it's very controversial and it's very difficult to identify the act performed in an official capacity. And in particular, the consequences of the qualification of an act as act performed in an official capacity could have important consequences in practice. Because if we consider that torture is an act performed in an official capacity, and I think it is, the consequence is that torture will be covered by immunity, and the author of torture will be protected against the foreign criminal jurisdiction, against the jurisdiction of another state. The issue is, of course, very complicated. I think that the main, I don't have time to make a deeper explanation on that issue, but I think that the main element to having in mind is the fact that it's not the qualification of an act as act performed in an official capacity is the result to the attribution of that act to states. It's not the fact that it is unlawful or not, because at the end of the day, if a national tribunal try to exercise jurisdiction, is because they consider that an unlawful act have been committed. Otherwise, the criminal jurisdiction will not have any capacity to develop any activity. And this element has opened a great debate about the existence or not, the applicability or not of exceptions to immunity of state officials. If we consider that torture, a crime against humanity, war crime, an act of genocide, an act of disappearance is an act performed in an official capacity, and if we don't consider that it's an act performed in an official capacity, a state will not be responsible of that act. If we consider that it's an act performed in an official capacity, what is the role appertaining to the new rules of international law, which purpose is protect values of the international law in humanity, human rights, the law of welfare, and others. If they are immunity, if they are immune, or if immunity is applicable to a state, to individuals committed, to a state officials, sorry, having committed this kind of act, that means that one legal international institution, immunity of a state official, could have a negative influence on the new international criminal law, because will bar and will prohibit the application of any the application of any rules for obtaining a declaration of responsibility, of criminal responsibility, with regard to the individual having committed this crime. I can that you could follow my argument. I'm cutting because I don't have enough time. There has been the issue of exception has been one of the most controversial issues in the work of the Commission with regard to immunities of state officials. The views of the members of the Commission, the opinion of the members of the Commission has been divided. In a majority, the majority of the members of the Commission are in favor of exceptions. Consider that at least we have to identify some kind of exceptions, identifying crimes under international law not covered by immunity, even if they are acts committed, performed under an as an in an official capacity. But other members had been expressed the opinion in the opposite side by the argument that only the immunity of the official is the immunity of the state, and for that the same rule has to be applied, and the state is immune even with regard the commission of crimes under international. Finally, I submitted to the Commission one proposal for identify some kind of a short list of crimes under international law that could constitute an exception to immunity of state officials. Finally, the Commission adopted this list. It is included in draft Article 7, adopted in 2017, and the draft Article 7 has the following drafting: immunity rationing materia from the exercise of foreign criminal jurisdiction shall not apply in respect of the following crimes under international law: crime of genocide, crimes against humanity, war crimes, crime of apartheid, torture, and enforced disappearance. And at any rate, I would like to underline that this exception apply only with regard to immunity rationing materia. That's it. These exceptions don't apply to the head of state, the head of government, and the Minister for Foreign Affairs, with a little nuance. It doesn't apply immunities. The head of state, head of government, and Minister of Foreign Affairs, where they are in office, continue to be immune, even if they have committed this kind of crimes. But when their term of office ends, they will be covered by immunity ratio materia. And from that perspective, after a certain time, the exceptions will apply also to the former head of state, to the former head of government, and to the former Minister of Foreign Affairs. Well, the adoption of these draft articles has been perceived by several members of the International Law Commission. The draft article was adopted by vote. It has been the first time in more than 10 years that the Commission votes, use the vote for the adoption of any decisions. And the adoption of this instrument has been perceived by some members of the Commission as an extraordinary rule, not without any base in international law. I can agree with that proposal, but anyway, I think that at least it is necessary to take into account that if we apply exceptions, we have applied at the same time some kind of procedural safeguards for avoid the possibility for a politically oriented proceeding of prosecution of an state official. For that reason, the last part of the work of the ILC focus on the procedural rules and safeguards. It is the last part of our work. We have adopted more or less half of the draft articles devoted to this kind of matters, and we will consider the remaining 6 draft articles next year. The purpose of the procedural provisions is multiple. We can identify different purpose for that rules. The first one is the intention to build an atmosphere of confidence between the foreign state and the state of the official. If there are clear rules of procedures related to notification, invocation, withdrawal, the possibility to transfer the procedure from the state of the official, the foreign state to the state of the official, the relationship between states will be easier, and it will be possible to work in a more convenient way. Second, the purpose is of these procedural safeguards is to set up some instruments in order to facilitate a fair balance between all values, principles, and interest in presence in a case involving immunity. And we intend also to include some draft articles related to this settlement of dispute to avoid controversies between states. The intention of the Commission is to finish our work next year in the first reading, and probably to finish all the final draft articles in 2024. Let me say something with regard for finishing my intervention. Let me say something about the immunities and international criminal jurisdiction. Until now, I have been speaking about the immunity before national courts. Now I would like to say some very brief ideas regarding to the immunity before international criminal tribunals, in particular international criminal court. International criminal jurisdiction is generally perceived as the last resort for fighting against impunity. In addition, that means that the intention by the establishing of this kind of tribunals, the international community intend to set up a judicial structure, international judicial structure, able to substitute the national jurisdiction when the national courts are unable to proceed against individuals having committed crimes of international law. From that perspective, usually some part of the doctrine and also in the framework of some members of the Commission consider that the international criminal jurisdiction, and in particular International Criminal Court, is the most adequate place for instituting proceedings against state officials. In fact, the International and International Criminal Tribunal is not submitted to the rule of parim notabilim imperium. Is in a vertical relation. It is in a vertical relation with the national tribunals, not in an horizontal relationship. And for that reason, it is considered that immunity is not applied. Before international courts, and that is right. It's right if you go to the statute of the Rome Statute of the International Court, International Criminal Court, you can see that the irrelevance of the public function is not considered to exclude the competence of the court. Look, for example, Article 27 of the Rome Statute. And for that reason, immunity doesn't apply to this tribunal. But this identification of the international tribunals as an alternative to the national tribunals in order to proceed against crimes, against the international crimes, is not absolutely correct. And it's not absolutely correct for the following reasons. First of all, I will make reference only to the ICC, yeah? Because International Criminal Court doesn't have an automatic jurisdiction. The consent of a state is needed. That means that only when a state accepts, the Commission, the ICC could go against a state official. Second, at any right, even if the state consent, the state accept the competence of the International Court, of the Criminal Court, the Commission has no capacity for proceeding against any state official. The practice shows that the Commission, the ICC has focused the exercise of its jurisdiction on specific officials, the high-level officials. And that means that a gap for impunity remains also before international criminal jurisdiction, before International Criminal Court. So what is my final conclusion? That it's not so clear that international criminal jurisdiction and national criminal jurisdiction are true alternatives for exercise the judicial functions with regard to state officials for the commission in the case of commission of crimes of international law. And we need to make some kind of, to establish some kind of relationship between both jurisdictions in order to avoid the permanence of impunity. Well, thank you very much. I have spoken a lot, I'm sorry, but thank you very much, and I open up any question you could consider.
Thank you very much, dear Concha, for your accurate and challenging conference. If there is any question, any doubt, I know it's very high level to begin with, but I mean, this is the challenge. Do you have any question? I have one question, if you don't have any, may I? It's about the connection between the international criminal tribunals or courts and the national courts. I was wondering about the consistency, the cohesion of the system, because we should establish a coherent legal order. So I'm afraid that there could be some not very connected jurisdictions or jurisprudence as regards the immunity of state officials in national courts or through the international criminal tribunal. So how can we establish a system in which we could guarantee such a coherence?
Yeah, I still think you Gracias. Thank you very much for the question. I think that it's not easy to, it's not an easy question, and it's not an easy, I don't have an easy reply to answer to that. But there are two important elements that I consider we have to take into account. First of all, when I'm speaking only with regard to immunity in connection with crimes under international law, of course, not immunity with regard to common crimes, ordinary crimes. Yeah? When we are thinking about crimes of international law, and we are thinking about the idea of the fight against impunity, we have different ways to obtain this this goal. One is, of course, the International Criminal Court or other international tribunals. There are some others international criminal tribunals, and the other is the national tribunals, the national criminal tribunals. When we are thinking about the exercise of jurisdiction, whether by international criminal tribunal or international criminal tribunal, we are thinking about achieve a goal for international community, which is the fight against impunity. So under this approach, I think that we need to set up some kind of interaction between international criminal jurisdiction and national criminal jurisdiction. The interaction must have different expression, different ways to be built. It could be cooperation between international criminal tribunals and national criminal tribunals. It could be the exchange of information, could be the referring case from the national tribunals to an international criminal tribunal. But the interaction is necessary and must be built on the idea that we both international criminal jurisdiction and national criminal jurisdiction, when they are working about immunity, about international crimes, they are part of a big system of international justice. When we think about international justice, we think always at International Criminal Court, but no. Some national tribunals exercise the same functions for achieving the same goal. And for that reason, I think that we have to think about that. The problem is, of course, how to define a good interaction method. And with regard to immunity of state officials, the only instrument we have is the establishing of to guarantee that exceptions to immunity of state official exist, and that the national courts will not apply immunity with regard to a state official having committed an international crime, because at the end of the day, they are the expression of one instrument of the expression of values of international community. But it's not a Pacific, it's a controversial conclusion. Yeah, it's not a Pacific. Some of my colleagues doesn't agree with that, and all the members of the commission and some state doesn't agree on that conclusion.
Thanks a lot for your exposition. For those of us who do not have like a legal background, many questions arise from your exposition. I have listed here like 6 different things, but as soon as we might be leaving soon, I'm just going to ask la más general, the broader question. And it would be, could you please provide an explanation or justification on how does the legal figure of immunity help or ease the lives of the broader public, the poor, the fisherman, the el obrero, and if it's not a tool to justify the power of the already powerful, because it sounds to me that immunity is something that helps the one that is already powerful, as for example the king right now or other people. My question.
Well, thank you very much for the question. Well, starting by the first issue you have put on the table, what is the foundation of immunity? The foundation of immunity is the protection of sovereignty of states. That is. They are not other foundation. But protecting sovereignty of states means protect the states, protect the law of a state, protect the institution of states, protect the equality in the relationship between one state and another. From that perspective, I think that I continue to consider that immunity of a state official is a necessary tool in international law. But the problem is not if it is necessary or not. The problem is the balance. We need immunity of a state official. My answer is yes. Yes, because we need to maintain the equality of a state. Otherwise, things, for example, I will put an example like that. Probably is more easy to understand. You are thinking about probably the current situation in certain information we receive in the journals even today. But I'm thinking about other things. I'm thinking when we speak about immunity of a state official, we are thinking about the protection of a judge, for example, having delivered judgment against one foreign citizens, and as a consequence of that, the property of that foreign citizen have been nationalized. But the property has been nationalized because after a legal procedure, it has been shows that no legal requirements has been fulfilled. The benefits are extraordinaries, are not ordinaries. For example, yeah, and the foreign citizens has a certain power in his country of national citizenship, and had the capacity to push the national tribunals of this of his own country to institute a proceeding against the judge, the national judge. Yeah. On what basis? There are some rationale for this that is the judge has fulfilled his own functions in accordance to the law. If it is, the institution of any proceedings, criminal proceedings before a foreign criminal jurisdiction could be seen as an injection in the sovereignty of the state of the judge. I think that we have to have that in mind. It's not only an instrument for protect the powerful people. It's an instrument for protect the state. Yeah. On the other hand, as I said before, the issue is not if we need immunity. The issue is to which scope. Which will be the scope of immunity? If for protecting the interests of a state, the right and the interest of a state, we attribute immunity, we recognize immunity to a foreign state, for example, a real case. The consul of Argentina in New York, at a certain moment, one consul several years ago, one consul sell several properties of states under an undue procedure. And that was under the order or on behalf of a state. And he was acting as an international representative of the state. In that case, it is logical that the state will the national tribunals goes to the consul of Argentina, or not, because it's an unlawful act, of course, but think, for example, in the case of Letelier in United States also, yeah, one official of from Chile, member of the armed force, killed the former minister Letelier, and killed Letelier as an act of state that was an act against human rights, etc. The member of the police of Chile was acting under orders and on behalf of the state, but the interest of the state in that case is so strong that could be considered before that the general interest of international community, which is protect human rights. I don't know if I respond to, I have responded to your question. That is the issue. It's not immunity. We have a strange approach, image of immunity. Immunity is not only to protect powerful persons, but we have to take into account that if we protect powerful person through immunity, we have to be sure that they have not committed any crimes under international law. That's all I can say. Sorry. I'm sorry.
Thank you.
Very good question, by the way. Well, Cristina, the last question, and we'll finish because we are out of time, okay? Very short, Cristina.
I'm going to be short.
Thank you very much.
Thank you very much, Professor Escobar, for a very insightful and excellent conference. And allow me to make maybe something that is there comment, because for me was very insightful what you mentioned, that in fact immunity is about protecting sovereignty and state sovereignty. But I'm a politolog, and I'm thinking, if sovereignty, we think about the state, but in fact it's about governments. And why instead of thinking about exceptions, can the Commission not think about limits to sovereignty? Thank you.
Thank you very much, Cristina. In fact, we in my fifth report, I have submit a dual proposal, including both exceptions and limits, because in fact exception and limit are not the same. But in practice, it has been the Commission considered that it was better to concentrate on the idea of exceptions. Why? Because defining sovereignty is very difficult. For the same reason, we didn't use the word the words authority, governed authority, or sovereign authority. We have decided to exercise functions of the states or represent the state, because I think that it is possible to make a distinction. It's possible to make a distinction. It's possible to identify limits to sovereignty. It's possible to identify what is the meaning of exercise of sovereignty, but it's easier to do it from a politological and sociological perspective, but it's more difficult from a legal perspective. And for that reason, we have decided to include exception, because at the end of the day, exception is exceptions is something, is a decision to exclude something that it was on the content of immunity. But limits, for identify limits to immunity, we need to identify what is out of immunity. And the main difficulty for so doing is to get some kind of consensus regarding the idea, regarding about the possibility to consider that act in a crime and international, the commission of a crime under international law is or is not an act performed in an official capacity. I'm fully convinced that it is an act committed it could be an act committed on an official capacity, because disappearance, torture, genocide, certain war crimes, certain the crime of persecution, for example, with regard to in the context of crimes against humanity. It is impossible to commit this kind of crime without the participation of the state. Yeah? But it is a matter. It is an issue. There are a debate, and for that reason, we consider that it's better from a legal perspective to keep on the idea of exceptions. I fully understand. But I can understand also the other perspective, the different perspective from my colleagues at the Commission.
Well, thank you.
Thank you very much.
Thank you, Cristina, for your accurate question, and thank you so much, dear Professor Escobar, Concepción Escobar, for your very, again, accurate, challenging, and deep conference. So we will declare open the NOAA program, and thank you so much also for the students for coming.